Meeting will be called to order, and preliminarily, I will call the roll. Commissioner Baker,
I'm here.
Commissioner Bluestone,
Here.
Commissioner Castillo,
Here.
Commissioner McMillan.
I'm here.
Good. Commissioner Solomon
Present.
and Commissioner Villanueva.
Here.
And the chair is here. So we have not only a quorum, but a full complement of commissioners. The next item is the approval of the agenda.
Mr. Chair, I would like to
Yes.
make a motion to move item 6, the State Ethics Commission media policy, and item 7, Commissioner Bluestone op-ed on procurement code, from this meeting to the next meeting.
Is there a second?
Second.
Thanks. Stuart, this directly addresses your point. I briefly, before I left my house this morning, saw that there was some discussion on it, but do you have any opposition to that?
I don't. We've had some good discussions, but
Yeah,
we're
that's what
not
it
really
looks like.
ready to go to the full commission yet. So
Yeah.
I think it's, I agree with Jeff and Judy that we
Great.
should just put it off for a month.
Good. Is there any opposition to the motion? Hearing none, the motion carries. So items 6 and 7 are hereby moved off the agenda and will be reset on the agenda for the April meeting. And it's the first Friday in April, whatever that is. I don't have that right in front of me, but it doesn't matter. Next is the approval of minutes of the December 15th meeting. Is there a motion and a second?
So moved.
Second.
Okay, any discussion? Hearing none, the minutes from the December 15th, 23 meeting are hereby approved. So we'll then move into the substantive part of the program. Jeremy, you want to give us a legislative update?
I'd be happy to. Good morning, commissioners.
Good morning.
In the December meeting, the commission asked for the governor to give an executive message to the commission's Governmental Conduct Act reform bill. And I'm happy to report that she did that, making that legislation germane. And a bill was introduced on the House side, House Bill 8. And we've been in the building more, I think, than we have ever been in any session, working to promote House Bill 8. And we've had large success. Commissioner McMillan has been in the building a lot, helping to speak with members about that legislation. And I'm very happy to say that that bill received unanimous do pass recommendations, both from House Government and from the House Judiciary Committee. And a few evenings ago, after the House approved House Bill 2, which is the General Appropriations Act, House Bill 8 was the first substantive bill that the House considered and unanimously voted in its favor. And so House Bill 8 has now gone over to the Senate. Yesterday, it was assigned to the same two committees that its predecessor bill last session was assigned to, Senate Judiciary and Senate Finance. And we're making a real effort this session to try to get this legislation passed. And yesterday we were back in the building. I had a long conversation with Senate Judiciary staff members, and I think we have a real shot at getting this bill heard in the Senate. And there's a real shot that we can get this bill passed, see it passed in this 30-day session. And so over the next week, I'll be watching the Senate Judiciary calendar pretty closely. I don't think that the Senate Judiciary Committee is going to get to House bills until about a week or so. But within the last week of the session, a lot can happen. And I think that I'm cautiously optimistic that there's enough support for this bill to see it across the line. So that's House Bill 8. That's the Commission's continuing efforts to improve the Governmental Conduct Act. And the other piece of legislation that we're always focused on is House Bill 2. This year, both the LFC and the executive recommendation matched the agency's request. And so we sailed through House Appropriation and Finance Committee, and the version of House Bill 2 that passed the House was exactly this agency's request for about $1.7 million, which will be enough to fund 10 staff members full-time, with ample amounts for contracts and for the other costs that we need to run the agency. And I don't anticipate that those line items will be changed at all in the Senate. And as in years past, we've also been approved for up to $30,000 in budget adjustment request authority in one of the latter sections of House Bill 2, which enables us to bar in some of the revenue that we receive from civil litigated cases. And so far, halfway through the session, a little bit more, I think we're doing better than we ever have. And I'm very pleased to report that. That's it, Chair.
Thank you. Anybody have anything, questions or comments to Jeremy about the legislation?
Jeremy, I just want to congratulate you again on the good work. I know you had explained to me that, and you shared correspondence that you had with Senator Dewey, and she seemed to be really actively involved in House Bill 8. And a lot of her comments led to the Judiciary Committee sub on the House side. And I'm wondering, have you had any more recent conversations with her? Do you have a sense of how she is viewing the legislation? I know it doesn't go to rules, which she chairs, but she's vice chair of Judiciary, I think you said.
So, Chair and Commissioner Bluestone, that's correct. There's been a lot of movement. Every day there's movement on this bill. And as of last evening, Representative Cates, the main House sponsor of this bill, who has been fantastic, had an encouraging conversation with Senator Duhigg about the bill. So kind of getting into the details a little bit, there was a floor amendment that I would have liked to have seen introduced on the House side that would have made one of the key abuse of office provisions, what we're characterizing now as what would be new Section 3.2A of the Governmental Conduct Act, should this pass, to tighten the language and to make it a little less broad, not overbroad, but at the same time not under-inclusive. And I think I solved that in a draft floor amendment, but the House isn't doing floor amendments. At least right now, the Democrats and the Republicans have an agreement not to do floor amendments on House bills. And so we didn't get the bill over to the Senate. That's kind of the last vision of the ideal version. But Council Service has prepared that floor amendment as a Senate Judiciary Committee amendment, and has alternatively prepared a Senate Judiciary Committee substitute, depending on how the Senate Judiciary Committee wants to see that language presented in that committee. That's an in the details conversation that I had yesterday for a while with Philip Laragoite, who's the main staff member for Senate Judiciary. And Judge Lang has also been kind of instrumental in communicating with Senate Judiciary Committee in that regard. So, every day there's movement on this bill. A lot of members have had contributions to the language. And again, Commissioner McMillan has been really instrumental in kind of helping navigate that.
Excellent. I don't think I personally know Representative Cates. Can you explain that involvement?
Sure. Representative Cates was one of the main sponsors of House Bill 5, the kind of analog of this bill last session. She's a Democratic member of the House from Sandoval County. She's from Rio Rancho. She's a realtor, and she is deeply passionate about government ethics, and knows this bill really well and defended it well in debate on the House.
Excellent. I also just want to add my thanks then to Commissioner McMillan and Chair Lang for your help. It's really important to have a presence over there.
Great, thank you. Anybody else? Okay, Jeremy, the floor is still yours. Item number 5 is advisory opinion 2024-01.
Okay, thank you, Chair. So Commissioners, this is our first advisory opinion of this year. It's drafted for your review and approval. It's the second in a set of advisory opinions that the Commission has been asked to consider an issue that relates to the procurement of attorneys in civil litigated cases on the plaintiff side. And in some ways, it's a follow-up to the advisory opinion that the Commission issued that opined that the procurement code applies to contracts for affirmative litigation plaintiff side counsel on a contingency fee basis. And this request is a little bit more in the details of how state agencies could go about procuring affirmative counsel on the plaintiff side. The request is tailored to the Attorney General's office, now the New Mexico Department of Justice. And it asks a couple of questions about the details of these kinds of procurement. So the first question is along the lines of, could the New Mexico Department of Justice issue a single request for proposals and award contracts to several plaintiff side law firms and have those firms on contract, and then select among the awarded firms particular firms for particular representations as the Attorney General's office or as the Department of Justice learns about civil claims in different kinds of matters. It could be environmental litigation, it could be consumer protection litigation, securities litigation. And so the first question that the advisory opinion considers is that compliant under the procurement code? Can a state agency, using one single request for proposals, award multiple contracts to several law firms? And then once the firms are on contract, the agency then picks among that list of awards for particular representations. And the answer to that question is yes. The procurement code allows for multiple source award contracts, so long as the procurement, the chief procurement officer of that agency makes a determination that that kind of procurement is necessary, that the one single contractor couldn't handle all of the work that the state agency needs to do by contract. And that's certainly the case with the Department of Justice. They handle many, many kinds of different pieces of affirmative litigation across different kinds of civil matters. And it's just not the case that a single law firm could handle that litigation, nor would that be in the state's best interest. And so the answer to the first question is yes, the procurement code allows for multiple source awards. And then once several contractors are on contract under a multiple source award, the agency can, by purchase order, assign particular contractors to particular matters of work. And the Department of Justice could do this kind of procurement under a single kind of global RFP for affirmative litigation in civil cases, or they could probably also do it by particular classes of cases. They could do an RFP for securities litigation, for environmental litigation, for consumer protection litigation, so long as that same necessity requirement is met. And the advisory opinion advises that they probably could do that. And two other comments about how agencies procure in this way. Risk Management Division has been using this section of the procurement code for a long time to use a single RFP to bring many kinds of civil defense firms into state contracts and then award particular matters, pieces of work under that single RFP. And you know, the advisory opinion just asks, can the Attorney General's office do that the same way on the plaintiff side? And the other kind of interesting thing to note is that the use of multiple source award contracts by a state agency, it kind of has an analog to a statewide price agreement. It's almost as though a single agency is using a procurement process that's similar to a statewide price agreement, but for that particular agency. And so multiple source awards are used often across different kinds of agencies where more than one contractor is needed. And so that's the answer to the first question. The second question that the advisory opinion addresses is there are circumstances in which the Department of Justice might not realize that the state has a claim until the state is on the eve of a kind of statute of limitations or a statute of repose or a kind of filing deadline. And the advisory opinion request asks in those kinds of circumstances where the state realizes its claim very late, could it use the emergency procurement provision to award a contract for a plaintiff side firm to pursue that claim without using the RFP process? And the advisory opinion opines that the answer is no, that really the text of the emergency procurement exception to request for proposals really doesn't allow for ordinarily an emergency procurement where the state might lose a claim because of the running of a statute of limitations. It's just not, that circumstance is just not an emergency as that provision understands emergencies for emergency procurement. But it shouldn't really pose a problem for the Department of Justice or other state agencies because if they awarded multiple source award contracts across different categories of litigation, going forward prospectively, if the state found out that it had a claim in a securities matter or in another matter on the eve of the running of a statute of limitations, if they have their ducks in a row and they've awarded several contracts to different firms in that area of litigation, if the state realizes that it has a claim late, so long as it has contracts awarded, they should be able to put a firm on that matter relatively quickly by purchase order without jeopardizing the state's claim because of the running of a statute of limitations, statute of repose. And so the answer to the second question is generally no. It's I guess possible that there might be a very rare circumstance in which the Department of Justice might need to resort to an emergency procurement for affirmative litigation, but not under the circumstances that the request posed. And the advisory opinion notes that. And that's about it, Chair. That's a description of this advisory opinion, and it's very good that the commission is being asked for advice on the procurement of these legal services contracts. I think we're making a real contribution to how the state does some pretty important business.
Thank you, Jeremy. Is there a motion and a second to adopt and issue the opinion?
So
moved.
That's moved and seconded. Any discussion, Mr. Baker?
no discussion.
Thanks. Commissioner Bluestone?
Yes, thanks. Jeremy, very well done. Thank you. It didn't occur to me until I was listening to you describe it this morning, and I haven't had a chance to go back and check the opinion about it, but is there a time limit that the opinion notes or should note with respect to such multiple source award RFPs and contracts, such that is it such that the AG could do it for a year or 2 or 3 or a term of office of 4 years, or is that addressed in the opinion, or should it be if it's not?
So, Chair, Commissioner Bluestone, that particular point isn't addressed in the opinion. I believe that that state contracts are are renewable up to 4 years. That's, I think I remember that from the CRB contract template. Obviously the funding for these kinds of contracts is appropriated year by year in all of the states. Contracts include these kinds of appropriation savings clauses, but I think that the general max term for a state contract is 4 years. And that's just in the background of our state's procurement and contract law.
Do you think it would help the opinion to note that in a footnote or otherwise before you release it? Just to add some clarification for how long these can be done. And I think you're right, but I don't remember that specifically in the law. And I would assume that risk management has to periodically do these contracts as well. But I'm wondering if you think it should be included in the opinion, but I'll defer to your thoughts on that.
Yeah, I appreciate that. We could easily note the max contract term in a note.
I think it might be helpful unless you object to it.
No, I don't.
That's all. Thank you.
Thank you. Commissioner Castillo?
No, I just think it's very well done, and I think it's good direction. And your comment about the fact that questions are coming to clarify issues regarding this is a good thing.
Thank you. Commissioner McMillan, anything?
No, thank you.
Thank you. Commissioner Solomon?
No additional comments, Mr. Chairman. Thank you.
The smiling cave person from Carlsbad. Isn't that the high school? The high school nickname down there, isn't it? What do they call the girls teams?
The cave girls.
Okay.
The rest of the town are cave people.
Okay. Well, then I said it correctly. Your
You
smile would suggest otherwise. Any comments, Judy?
No, thank you.
Thank you. Nor I. Okay. It's been moved and seconded. We had discussions. There will be an addendum made. We don't need to formalize that through well, maybe we do. Is there a mover in the second? Seconder are amenable to the edit as suggested by Commissioner Bluestone and agreed to by the author?
So moved.
Second.
All right, moved and seconded and amended. Anybody opposed to the issuance of this administrative opinion 2024-01? Hearing none, it passes unanimously and let it issue. Thank you, Jeremy.
Yeah.
Okay.
Before we move on, I just want to note that Casey helped in the drafting of this opinion. So thank you, Casey.
Thank you. Yes, Casey, thank you for recognizing that. Okay, the next item is the first of the two public comment sessions. This would be the pre-closed session comment. So Walker, you're usually the mayor domo of this particular procedure, so I'll let you.
Thanks, Chair, but I think this august duty has now passed on to Jane, and so I will let her do it.
All right. Well, you did a fine job for those years, and I hope you don't miss it. Jane, it's all yours.
Thanks. So if there's members of the public that want to make a public comment at this time, go ahead and raise your hand and I'll call on you and you can make your comment. It doesn't look like anyone has raised their hand.
All right. Thank you. Then we will move on to the next matter, which is to seek a motion in a second to move into executive session as provided for by statute. Is there a motion a second?
So moved.
Second.
All right. Any dissent? Okay, everybody's agreed. We will now move into executive session, and I will give staff time to move everybody to the appropriate rooms. Join your breakout room, folks. All right, we have had a motion and a second to adopt the recommendation to pursue, the request to pursue a civil action. And as I said, there's a motion and a second. Is there any discussion on that matter? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Mr. Solomon,
Yes.
Mr. Villanueva.
Yes.
Chair votes yes. Motion carries. The civil action is hereby authorized. And the next item is number 14. Becky, did you find your way? There you are.
Yeah. Staff asked the commission to issue the default order in case number 2023 NPO2 in re the commission of Margaret A. Nava.
Is there a motion in a second?
So move.
Second.
Thank you. It's been moved and seconded to issue a default order. And is there any discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
and Commissioner McMillan,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and the chair votes yes. Thank you. Motion carries. Let the order issue. Thanks, Becky.
Thank you.
Item number 15, Walker and Jessica.
Chair and Commissioners, thank you. Commission staff seek an order approving the settlement agreement between the General Counsel and the respondent in administrative complaint number 2023-25, Roger Rael versus Stephanie Lord.
Thank you. Is there a motion, a second?
So moved.
And Commission, any discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. Settlement is agreed to. The next item, I believe, is yours, Jessica.
Thank you, Chair. Chair, members of the commission staff seek an order approving settlement agreement and dismissing the complaint in administrative matter 2023-36, Ramona Goolsby versus Howie Morales.
All right, is there a motion and a second?
So moved.
Second.
Thank you. Any discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Mr. Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. Settlement is agreed to and adopted. Okay, next is administrative matters under the Ethics Act. Jeremy?
I think Casey will stand in. Thanks, Casey.
All right, you want to do the whole deal? Great. That's right. I'm just looking at your name. Sorry, Casey, it's all yours.
Okay, thank you, Chair, Commissioners. Staff seeks a 90-day extension under section 1016G 11A for case number 2023-027.
Okay, is there a motion, a second?
So
So
moved.
moved.
All right, it's moved and seconded. Any discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. The extension is granted. Next item.
All right, Chair, Commissioners, for administrative case numbers 2023-034, 2023-047, 2023-048, 2023-049, 2023-050, 2023-051, 2023-052, 2023-053, 2023-055, 2023-056, 2023-057, 2023-058, 2023-059, 2023-060, 2023-061, 2024-001, and 2024-002. Staff seeks dismissal of these cases for reasons that will be set forth in their respective and individualized orders.
Okay, and is there a motion and a second?
So moved.
So, second,
Thank you. Any discussion? All right, any, Commissioner, what's your name? Baker.
Hey,
Abel Baker Charlie. All right, go ahead.
yeah, the potted plant.
Your words, not mine.
Thank you. Yes.
All right, Commissioner Bluestone,
yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
yes.
and the chair votes yes. Thank you, Casey. All right, that concludes the substantive portion of the day's meeting. The next meeting, does anybody had the time to figure out when the first Friday in April is?
April 5th.
All right. Can we have the next meeting April 5th at 9 a.m.? Has anybody got a heartburn over that? All right. Hearing no quarrel with that, our next meeting will be on the same time, place, etc. On April 5th, 2024. Once again, we open for public comment at this time. Jane, I leave that in your capable hands.
There are no members of the public on the meeting, I believe. Oh, there is one. If you have a public comment, go to reactions and raise your hand and I'll call on you. And you can make your public comment. It doesn't look like any hands were raised.
Thank you very much. All right, that being the case, we will stand adjourned. Stuart, try to endure the rest of your sentence down there. And as for the rest of you, it's always good to see you. I wish we were all in person, but then again, nobody had to get in the car and go anywhere except for the long-suffering chair, but it was the least I could do. Okay, thanks, everybody. Be well, and we'll see you down the road. We are.
Thank you.
Sounds good.
Thank you.
Thank
Thank you,
you.
everybody. Bye-bye.
Everybody be safe.